We may not want a guardianship to happen, but sometimes it's inevitable. What can we do to minimize the delays and frustrations associated with a guardianship of either the person or of an estate? Hi, I'm John Strohmeyer with Strohmeyer Law, where we help our clients leave no unfinished business. Now, part of estate planning is planning for not only death, but also future incapacity. Nobody knows or really can be certain if they'll lose capacity before they pass away. But we are, as a society, living longer lives, which makes it more and more likely that we may end up being in a guardianship. And even if we're not in a guardianship, we're probably going to lose capacity before we pass away. Now, to speak from personal experience, my father was actually in a guardianship for the last few years of his life. He had Parkinson's and dementia, which at the beginning wasn't a problem, and he was still able to take care of himself, make his own decisions. But eventually it got to the point that my sisters and I had to move forward with a guardianship for him. My sister and I ended up taking turns being the guardian of his person. So we made decisions for him about where he lived, what sort of medical treatment he was getting, and what that looked like, and even where he lived and what happened. We weren't the guardians of his estate, and that was actually taken over by a bank who controlled all of his assets so that they would be managed by somebody who wasn't in the family. This was a delicate situation. It took a lot longer than we wanted, and even with the best of planning, it still may come down to somebody's making decisions, and you still have to take control for them. This guardianship can be a delaying and frustrating process for everyone involved because ultimately it involves taking away the rights of a person and assigning them to someone else. Now, I was talking about when we were the guardians for my father. He was an adult, he had lost capacity. We had to show the court that he just wasn't capable of making those decisions for himself any longer. But it may also come up for a minor child. But if their parents aren't there, then that child would need a guardian of their person whom they'd probably live with and would definitely be making those feeding, clothing, and sheltering decisions. Whether you'd need a guardian of the estate for the child will depend on whether there are any assets there for the child. Even in a planned estate, if you have trusts set up for your children, you'll probably need a guardianship for their person, someone who can make those decisions for them. But when it comes to their estate, you may not. And what we see a lot of is that parents will name the same people as guardians of the estate as they will to be trustee of any trusts for their children. The roles naturally overlap. But thinking down the line, what can you do to minimize these headaches and frustrations of a potential future guardianship, either for yourself or your minor children? Well, long before anything happens, the first thing you want to do is make sure that you've actually declared who you want these guardians to be. Here in Texas, you have the ability to name guardians for yourself if you ever need a guardian for yourself. So you can name guardians of your person to manage your feeding, housing, sheltering decisions, medical decisions, things like that. You can also name a guardian of your estate, someone who will manage your assets. You can also make the same decisions for your children. And typically, this is what we're helping clients do. Once it comes down to minimizing the headaches if a guardianship is actually necessary, what else can we do? You want to make sure that you've talked to your future guardians to make sure that the people who are going to be appointed know that you have them in mind. This makes sure that they know if something happens, they're ready and can potentially come in and know that they're going to be responsible. Additionally, it also lets them know that they have the opportunity to say, this isn't something I as the proposed guardian will be able to handle. For any of a number of reasons, a person may say, I'm just not capable of doing this. And you, the person who's potentially naming these guardians, should respect that. If they say they can't do it, you probably not name them. If your proposed guardian is telling you that they don't want to be named, you should respect their wishes and not name them. Even then, it's possible down the line situations will have changed, and the proposed guardian will say, look, situation now doesn't allow me to serve as guardian. I'm not the right person. And so that's why you want to make sure that you're naming several successor guardians. What you also want to do is make sure you've talked to anybody else who may be upset that you haven't named them as the guardian. For parents thinking about having grandparents named as the guardians if they're not there, or siblings, uncles, cousins, whoever it may be, making sure you're talking to everyone involved so they don't think that they've been left out unfairly. If you give them the chance to address that and talk to them and at least let them know that they're not being named or they're not the first named for whatever reason, it helps you ensure that the right people get appointed at the right time. But if we have guardianships, if we need one, what should we be thinking about at that point? Well, this is a court mediated process. And because of that, there are some roadblocks to ensure that a guardianship doesn't get created automatically. Here in Texas, the first thing the court looks to is there a lesser restrictive alternative to a guardianship? What this means is the court is going to look to see if there's a better way, something that's not as restrictive, as consuming, both financially and just legal process wise, to take care of someone, just to make sure that we're not imposing a burden on everyone involved. When it comes to the guardianship of the estate, if a person has a revocable management trust or perhaps powers of attorney that can be used to manage their assets, this is a lesser restrictive alternative to having a guardianship of the estate created. The guardianship of the estate is going to be a consuming, expensive process in a lot of cases because it's going to require that that guardian of the estate take and manage all the assets and file annual accountings with the court to declare where everything has gone and what has been spent on all those assets. So as we look to what the guardian of the person is obligated to do, well, they're supposed to take care of the ward, the person who's in the guardianship, their physical, emotional, and educational needs. Texas law provides that the guardian of the person has the full authority to the possession of the ward and establish their residence. Again, that guardian is going to be the one who's in charge of finding appropriate sheltering for that person. It doesn't actually require that the ward live with the guardian. And going back to the example with my father, my dad never lived with either me or my sister full time. And the nature of his condition was such that we weren't going to be able to provide him with the care that he needed. We went and thankfully were able to get him the appropriate care for him so that he was able to be taken care of in a way that allowed him the best version of life that we could as the Parkinson's and dementia took hold for him. Now, as the guardians, though, we were the ones who were there to consent to medical treatments for him. We were the ones who were talking to the doctors, but we also made sure that we were talking to Dad to make sure that he knew what was going on. We wanted to make sure that he was involved in any decisions, and it wasn't just something where we were making decisions without getting his input. It really was meant to involve him in the process. Now, because we were responsible, we also had to make sure that he was able to get around and get to his appointments. Again, it wasn't necessary that we be the ones who actually take care of it, but we had to make sure that it got done. And based on his living conditions and where he was living at the time, they were able to help us arrange for that. Beyond just making these decisions on an ongoing basis, as the guardian, there are annual reports that Texas law requires be filed with the court. Now, every year, every 12-month period, we had to file a sworn or affirmed report that talked about what we had done, the condition of our father as the ward in the guardianship, and just letting the court know what was going on. The court would follow up if they had any questions, but it was meant to be sure that there was some accountability for us as guardians of the person. Now, turning to guardianship of the estate, what's going to happen? Well, first and foremost, the guardian of an estate is required to take possession of all of the estate assets, meaning that if there's anything that the ward owned before they were declared incapacitated, that guardian is then responsible for going out and collecting them. So this means making sure that they've found all of the assets, bank accounts, real estate, shares, brokerage accounts, investments accounts, retirement accounts, whatever it is, that guardian is responsible for collecting those. Once they've got them, they're responsible for investing and managing them appropriately. Now, the guardian is a fiduciary, and they're therefore responsible for taking care of the ward's estate even more carefully than they would take care of their own property. At no point does the ward's property become the guardian's property. It's on the guardian to make sure that they're investing appropriately and not using any of those funds for their own benefit. And one of the first things that the guardian has to do is establish separate accounts to ensure that the ward's property is not commingled with the guardian's property. This can be done by having accounts titled, John Strohmeyer, Guardian, to ensure that it's clear that those are not assets that belong to the guardian. They're there for the ward only. In addition to collecting the assets of the ward, the guardian's also going to be responsible for making payments on behalf of the ward, using those assets in such a way that they are only for the ward, and then getting court approval on those to ensure that everything is taken care of. At the end of every 12-month period, just like the guardian of the person has to file an annual account, the guardian of the estate also has to file an annual account, showing the property on hand at the beginning of the year, showing where assets were spent, what was received, and being able to account ultimately for every penny that came and went to ensure that the ward is being taken care of. Again, the ward is someone who has had their rights taken away from them. They shouldn't have someone who can take advantage of their assets, and that's why the court procedures are there. So there's a lot of work involved in being a guardian. When you think about this, there are things that we can do to minimize those headaches at the front end. First, making sure that you've named future guardians for yourself and for your kids so that if it ever comes up, you've let people know who you want to be in charge. Potentially having your own sets of powers of attorney to enable people to make decisions on your behalf and in accordance with your decisions will also stem off the need for a guardianship later on. If a guardianship does actually become necessary, make sure you've talked to your family and the people you're naming so they know who's in charge, and any fights that may break out because somebody is upset they weren't named can be minimized later on. Finally, if you actually end up serving as a guardian, either as guardian of the person or guardian of the estate, make sure you're taking good records so that you can report to the court on what you've done to keep your position and take care of your ward. Thanks so much for watching. We'll see you next time.